Welcome, everybody. My name is Mark Shope. I'll be the moderator for today's presentation or faculty workshop. I am a professor at the 阳明交大学 School of Law. And today it is my distinct pleasure to introduce two very distinguished scholars, Daria Bulgakova and Polis. Daria is currently a visiting researcher at the Department of Law at Uppsala University in Sweden. She obtained a PhD in international law at the University of International Business and Economics in Beijing. And her research expertise includes internet law, cybersecurity law, personal data protection law, biotechnology law, AI and Internet of Things and law. And Polis is a security professional with over 17 years of professional experience in legal security in Latvia. He is a scholar at the BA School of Business.
Yeah, School of Business, BA.
Okay, BA, School of Business and Finance in Latvia. And apologies to the scholars. Feel free to add anything to your introduction as you see fit. But today's topic is the status quo for digital identity technology. And I guess without further ado, Daria, the floor is yours.
Thank you so much, dear Mark, for introduction. My pleasure to be right now here and present the studies about the status quo for digital identity technology. And I want to also thank to my colleague from Latvia, Polis, for our cooperation to make possible this study. Also, I want to say thank you for the Faculty of Law of the National Yan Minchao Tong University in Taiwan, and specifically for the Dean of the Faculty of Law, Professor Thomas Chen, that also helped me to find out the problems of the digital identity technology as well. Yeah, let's get started, and just please 1 moment, I'll share my presentation with everyone. I hope that today everyone feel well, and I hope for interaction in the process of the workshop, and I'm looking forward at the end of the study to hear some questions and maybe some comments from your behalf. Yeah, let me share the screen, and I will start. Okay, just to make sure that everything is correct, Mark, please can you confirm that you see my presentation and you can hear me properly?
I can hear it and I can see it very well.
Okay,
thank you.
Great. Thank you so much. Yeah, my name is Daria Bulgakova, and Mark rightly said that I got my PhD in international law in China, in Peking or Beijing City, in the University of International Business and Economics, and the Faculty of Law. There I did my dissertation about application of the principle of proportionality on biometric data processing in European Union law. And I was specifically focused on the GDPR issues of the Article 9 and try to find the balance of the prohibition of biometric processing and the exceptions provided when the biometric can be allowed to be processed. Now I'm very glad to do my already postdoc studies in technology law. So I basically try to find the implementation of my knowledges that I have gotten in China about biometric, specifically about facial identification and finger identification, that is relevant to be taken from the identity perspective of a unique recognition of a human being. And for me now, it's fundamental to understand the next stage of research. And I believe that the status quo, the fundamental base, can found some rooms that can be relevant to move forward further for biometric implication. Yeah, and I want to thank you so much for National Yamin Autonomous University for host this workshop. I think that my thanks also refer to the thanks from Polis as well. And before us start the studies about technology law, about human being, I was trying to think what methodology I can apply for this issue. And besides of the legal dogmatic framework that is usually used by legal scholars, I believe to find out this modern question, it's relevant to refer not only to the common use of legal framework, but also the present scholars need to understand how the technology is created and how the law apply from the perspective of the art science as well. And the artistic work try to to provoke my imagination in order to understand the relationship between law and technology, and how identity, what the role of what the place of this identity in this field. So I'm looking forward for the artistic works that could be relevant for my studies. And I found out that in past, the famous avant-garde artist and also theoretical artist, his name is Kazimir Malevich. He was born in Kiev in Polish family. And but besides, he also refers as a Russian artist because a lot of his work now presented in the Moscow. And one of the work is the Black Square. This Black Square work was also presented in 1915 in the Tretiakov Gallery in Moscow, and this Black Square provoked a lot of thinking for not only artists, but also for philosophers and other fields of science. When I look on the black box, I think that it's very relevant to correlate this square to the technology, because I could interpret the technologies as the body that is unknown for us. Basically, legal scholars, in my opinion, don't have enough knowledges, technical knowledges to understand the protection of the legal identity through the identification process that is made possible by technology means. So I would prefer to first understand what the technology is. When I look on this black square, I would forward the idea that fundamental about this. So basically, the Kazimir Malevich, he tried to provoke the society and think further that about equality and about the landscape that unknown for us. So this create box of problem that is need to be solved, and this black box of problem is relevant from the form of shape of this square and also for the color that is used. The color is also provocative and up to the educational knowledge that you have, you can also interpret this black box differently. But I see it very close to the technology interpretation as the main body that secretly from us somehow, just to play with data. I don't know about you, Mark, of how you would interpret the black square that presented Kazimir Malevich in past. How you see this black box for your imagination? Can you please forward your thoughts about your ideas, how you would correlate, how you would find the possible lines of this black box to the problems of the digitalization of the society?
Well, the first time I see the black box, my thinking is, why is it called the black box and maybe not the white background or the or why focus on the black box, right? And maybe, I guess, so then the issue is an issue of interpretation. And how do we go about interpreting kind of approaches to right, to this piece of artwork, but maybe to the issue of identity and technology.
Yeah, thank you for your support about this representation of the status quo for digital identity technology. And how about Gatis, you? How you would see this black box? I know that your expertise is related to the cybersecurity things. So how about your technical point of view of the risks that can be seen from the black box for the identity? What risks, in your opinion, can be seen from this idea?
Thank you for the question. Speaking of digital identity, in my thoughts, we need to speak also about security. How we safeguard our identity, our data, what safeguards is implemented to deactivate malicious activities. And one way is to speak and get better understanding of cybersecurity, also aspects of ethics. Simply put, it's all about professionals who safeguard information, but that's not all. Also, thinking about this square and the black box, we need to think also about our perceptions of security, our perceptions of ethics. Also, the main and the big thing, it's our perceptions of cyber hygiene, how we follow it, what we do. And as a black box, also in airplanes, the black box is meant to get information, what has happened. And we need to go through a lot of data analysis, a lot of security issues, ethical issues. The main thing is what we have to protect and what is needed to be protected.
Great. Thank you so much, my colleagues, for your opinions about this important field of the study. So I do agree with you that it's relevant for identity, and we also have to think about the cybersecurity aspects while we process the data by machine. So the actuality of the proposed study is formulated by increasing popularity of biometric data processing and by machine learning about the human being. This framework became crucial for commercial business growth and competition policy that try to produce the best technology that can satisfy the new needs of society to be digitalized. Another example of this framework can be found now in the book of Frank Pasquale. He presents the book about the black box society This book represents idea about the secret algorithm that control money and information. So correlate idea about the black box and about the society that is already like digitized, and we all involved in the process and framework. I would recommend to read this book if you will to know more about big data impact and about how our behavioral moves in the network connected to the business policy as well. Besides of that, talking about Kazimir Malevich in 1927, he also presented his book about the non-objective world that also would suggest to read more to find out the black box deeply. To understand the box and what parties involved is need to think about the categorical aspects of these parties, and from the doctrinal approach I would refer to the three relevant players of the black box processing. And those players, in my opinion, are technology, human, and network. For scholars that involved for legal studies, sometimes can be not understandable why the technology and network are seen as the players, how they can be interpreted as a parties of these relationships. But for me, it seems to me that human interact and to make possible have representation of the identity in the cyberspace, the human need to interact not with the legal authority first, not with the institutions first, not with the business first, but first the human interact with the machine. And machine is a kind of equipment that can be seen from the technology approach and from the network approach. I add here network because data processing is just not possible to be done while human interact only with technology. Everything is connected to the internet, and all risks also relevant to be discussed not only from the technological measures, but also from the network measures as well. I put human in the middle of players because the human is the main source, in my opinion, the main source of the data that is provided for this equipment. So while the human provides a source, so he's a subject of the box. And data provided is an object for the processing. Technology and network are seen from the perspective of tools that correlate with the data provided. So I propose the definition what the digital identity technology is. This is the body of automated command-based equipment that comprises of identifiers and patterns for the purpose of individuals' detection through the human technology network interface. And all of them, human is equal to the technology correlation, and human is equal to interact with the network interface. To explain much more deeply about the relationship that need to be regulated from the legal perspective, I would refer not only to the science of art. In my studies, I also prefer to use the approaches of the mathematics. in this case, the approach is used with the formulas of geometry. So in order to understand how these three players interact between each other, I would refer to the rule of the triangle. By this reference, we would be able to find out whether the relationship have to be applied equally or not to each other. From the geometry perspective, triangle has three vertices. And typically talking, a triangle with the vertices usually interpreted as triangle of A, B, and C. So through the interaction of A with B, or A with C, C with B, we can see the denotation of the players' interaction. Besides, the length of the legal relationship have to be understandable from the application of the purpose limitation, because each of relationship that need to be found, they're always limited. So based on the length of each of sides, we can find how these players interact. For instance, besides of the first, the middle triangle that is called isosceles triangle, there also exist another two kinds of triangles. That is, the first one is called equilateral triangle. So I believe if we can be able to apply this triangle for another framework, we will talk about the legal relationship between parties that are equal with tasks and equal with the rights and responsibilities. Another possible triangle that can be applied for the same of legal relationship is called the scalene triangle. So basically, in this kind of legal relationship, none of each party is equal. None of the tasks, rights, and responsibility is not equal. Everything has own targeted statements in order to behave with these legal relationships. So back to our legal relationship that include the digital identity technology, I would prefer to interpret the status quo of interaction, non-equal relationship between human technology and human network and technology network. Because human technology and human network are equal because human by itself, by its nature, already dictate the rule of conduct by human being representation. And technology will be relevant to the network because they are coming from the technological means that can be seen from the also logical perspective as well. In order to understand how the ABC interact, how human technology and human network could be, targeted to each other, I would prefer to propose the formula that can be useful to better understand this correlation. So talking logically, in order to solve our problem, our black box, we need to have input, which is logically A and B, in order to find output, and that is C, a result of this black box interaction. Talking theoretically, we'll add technology and network in order to have the human representation through this technology network interaction. Talking legally, because my expertise is related to the European Union law, as I would use the legal framework from the European Union perspective. And one of them, the Cybersecurity Act of 2018, that is relevant to solve the cybersecurity risk that my colleague Polis will help me to solve later on his speech. Plus, to this Cybersecurity Act that is equal to the technology means, talking about the network, I have found that Regulation Privacy and Electronic Communications of 2017 can be relevant to solve the privacy risk and also the processing risk of data. So these two frameworks are the law for the study, the base law of the study. Speaking practically, we also have to think about, okay, what the examples or what the case studies exist right now. And I have found the expertise of France, that is a member of the European Union. And France, one of the states that first allow the processing of biometric data that is actually negatively was evaluated by the experts in the data protection field, because GDPR in principle forbids the processing of biometric. But because also in Article 9, the member states can have the specifications about this rule. France did their national framework that used in my study as example. And example from the technological perspective, the France state certified online application on mobile that is called AliCam. So this technological platform helped to French nationals to identify them in the cyberspace. On another hand, talking about the network, we need to think with what data play this ground. And this is facial data or facial recognition, as it also commonly seen in some articles. So through this framework, we'll find out the practical solution for digitized legal identity. Continue to talk about the players and the parties involved. I have divided the black box of the one main black box through another small pieces of these dots. And to understand much more deeply about ABC, we also have to understand how this ABC can be seen in reality. Talking about A is the cognitive perception. So basically the technology that is involved for digital identity has a brain-like functionalities that is compared to the brain possibilities of the real human being. So basically the cognitive perception has characteristics to understand the information and classify this information. So the brain-like characteristics that is relevant to us, to human beings, now already developed in the technology. Talking about B, we have to understand B, the network interaction with human through the consciousness of internal and external existence. So basically, all of us, we have our ID card that we can, present for some authority in order to recognize us as a particular person, like me, Daria Bulgakova. But talking about my internal presence and talking about the identity processing through the technology involved, I would say that B right now can be seen from the perspective of the capacity of the personhood, where we have our legal validation of our presence in the cyberspace. Talking about the C, the human, from the ethical perspective, usually try to figure out what is wrong and what is right, what is compliant, what is not compliant, what can be understood as a good or what can be understood as a bad. So also this idea, the possibility of human interpretation of the environment around him can be seen from the algorithmical conceptions that machine now use in their functionalities. So the status quo for digital identity technology is a capacity to recognize, to apply, and to perform. Besides, ABC boxes is also can be understandable from the perspective of sense of justice. Or if you will, we can say that the status quo for digital identity technology is the sense of self-evaluation of the justice that is now can be seen in the technology existence as well. So we have the three core of our black box of problems. The first one, which is A, from the legal perspective, legal point of view, is understandable from the possibility and from the need of the person to be aware. The technology have to provide enough information about how data is processed and what the risks are possible. To be aware is also the fundamental value of European Union that it can be found in the data protection field of the study as well. To be aware about what is going on with the personal information provided, with the identities that is used and that is processed by technology, the person have to decide what can be done next. And this perception can be seen from the second value of the fundamental framework of European Union as freedoms. Freedoms to act as a valuable unit, not only in the society, in the reality society, but also have enough of freedoms to act in the digital society. To be able to be free to make a decision or terminate or stop the processing of identity. This also can be seen from the perspective of prevention of the possible risk. Because from the human-centric approach that is ruled by European Union, freedoms are the crucial power to comply with this approach. Talking about C, we need to understand that human cannot be enough strong in the cyberspace. In order to provide some additional tools, we need to think about the mechanism that can be seen from the perspective of hand of human. These hands that the human can have in the cyberspace, I see from the mechanism of the security, privacy, and data protection. Three of them are also fundamental because they're also granted in the Charter of Fundamental Rights of European Union. So this mechanism, together with awareness, freedoms, seen as a free for digital identity technology. Next, to finish with the legal framework that you can see in the left side of the screen, we also have to think further about the technological perspective that is relevant to be made and found out. The technological means interact with the law through the perspective how we understand the status of the human being in the cyberspace. The idea is that this status has a new approach that is called quantified self-status. Quantified self-status is relevant to all of us because we now provide our data to be tracking. So basically the human being interact with technology, network through the personal freedom to be involved here. That's why it's called self-tracking. Besides, after as we self-tracked it, the personhood see itself in the cyberspace through the particular numbers. These numbers are representation of this identity. Because, for instance, talking about the finger identification or facial identification, and from the perspective of GDPR, biometric data of our finger is not biometric, by just by magic. In order to become biometric data from the terminological perspective, the person have to provide biometric characteristics, which is not a data. Our finger lines, our facial characteristics, just the former stage of this processing. So through the processing of physical, physiological characteristics, we have outcome of biometric data that is only possible through the automative approach. The same true with this quantified self-status. We see our identity and our recognition is made possible through the numbers. Self-knowledge through the numbers is our existence in the cyberspace, in our box. Because numbers from the mathematical perspective also have to interact the technology, the manufacturing, the providers of these innovative designs also need to find out how these numbers can be performed in order to be recognized as a finality of this processing. That's why we need algorithmical conceptions. We need algorithms in order to satisfy our legal capacity, our digitized legal identity. So from the quantified self-performance, the personhood became algo-quantified. Now you can see the correlation of these statements. Awareness relevant to self-tracking. Data protection, privacy, security is relevant to the algo personhood. Freedoms relevant to self-knowledge through the numbers. And that's how the triangle that I presented in the beginning of my presentation can be understandable from the legal and technological perspective. In order to found the major power who call for this digitalization, I also propose to use, besides the European Union framework, the framework of United Nations. United Nations in 2021, they called globally for the identity, for the digital identity for everyone. So the law have to be changed and have to be modified in each of states, in each of countries, in each of continent, in order to comply with the global needs to be digitalized. Talking about the European Union framework, because for European Parliament and other institutions, it's important always to promote the rights of the human being. European digital rights is a new central, let me say like this, is a new approach that try to develop based on the Charter of Fundamental Rights of the European Union, the new code, let's say, that can be seen from the perspective of guarantee and safeguards our identity in the cyberspace. This guarantee seen from the fundamental approach through the rights. So this rights is developed through the triangle mechanism that I just presented. Next. Besides all that triangle mathematical methodology that I have applied, we need to back to our art methodology about black box of Kazimir Malevich. In order to find out the digital identity technology, we need to understand how law protect this identity and how law is interacted with human. For this, I would propose the practical part of the study that is found in France. So, as I would say in the beginning of the presentation, the France authorized through the AliChem application that is certified and legalized in France. So AliChem can be seen as a tool of quantified self-application in this mechanism. Talking about the human status here, or human representation, is a little bit changed, because while we interact with the technology, we became users of these applications. So I propose another possible line of the party is a quantified self-user, which is French nationals. Talking about the quantified self-law, on example of France, there is a decree 2018-452 that you can find if you would like to read more about this. And talking about how this application, how user and law ensure the quantified self-status, we also need to think about the technological approach, about the process mechanism. And this is NTC, the new security approach that behave as a protectional tool from the cybersecurity perspective. And this cybersecurity is ensured in the server of the box of our identity. So this approach is quite new because talking legally, Article 9, Para 1 of the GDPR explicitly prohibits to process the biometric because there's a risk to be not compliant with the human-centric approach, because from the ethical and moral perspective is also problematic for human beings to be that much split out in the technology. But on another hand, because member states also have some power to interpret the national law, there is a possibility to allow this quantified selfification. And that's why Para 2 of Article 9 of the GDPR allow the processing of biometric for digital identity use as well. France is the state country that do so. So, back to the decree of 2018, the France authorized the unique identification. This is called the certified online identification on mobile that allow the facial identification based on the exception provided. So the Alicame app is used for smartphones, for mobile equipment by French nationals. So while the facial data is processed through this Alicame application, they can have access to the, for instance, electronic market for the communication with the public authorities and so on. The new rights also have been developed for this Alicame app framework. To be precise, the Alicame made possible for the users to be recognized in the cyberspace and have the new kind of responsibilities of rights in this cyberspace. In order to understand why France made possible to allow the processing, because on the other hand, the GDPR has explicitly prohibited this evaluation, we need to refer, besides of the GDPR, again to the fundamental framework, which is Charter of the Fundamental Rights of the European Union. So while the right to personal data protection is guaranteed in the Charter, but on another hand, this right is not absolute. So while this right will be in risk to be somehow limited, the European Union approach proposed to apply principles that can help to use this right, to realize this right when there is a necessity to limit this right. And one of the principles that is coming from the Article 52 of the Charter of Fundamental Rights, European Union, Part 1, the right to personal data protection is a subject of the principle of proportionality. That's why France allow this processing, because they really they found out how to apply this principle when, on another hand, the right to personal data protection is, limited and not guaranteed that much as maybe someone want to do so, because from the perspective of the digital benefits, of the digital goods, of the welfare of the society, we need this facial identification. There's a necessity to interact with the cyberspace. And in order to avoid be only anonymous users in the cyberspace, French proposed to call for the legalized presence. So everyone can claim as that me, a particular person, me, Daria Bulgakova, I have my legal capacity in the cyberspace. So the authorization of unique identification is proportionate to the aim that I just mentioned. Besides, it's proportionate to the essence of the right to data protection, because besides of the possibility to be recognized, the France also provides some technical and organizational measures that can safeguard this right through the technology network interaction. Besides, AliCAIM provides suitable and specific measures for another fundamental rights that interact with data protection, for example, data privacy or security, or another 3Q that I have been introduced before. And this is the interest of the data subject to have the digital identity. Next. The dispute and the problem that have been found from the negative outcome of this solution coming from the deliberation of National Commission for Informatics and Freedom, because before us this decree was introduced in 2018, the Commission in 2018 made provoke a dispute that is not proportionate. So it was a call for the French hires administrative call to find out, to solve the problem, whether this principle is really can be seen as a measure that can be argued that right to data protection is not absolute, therefore we need facial identification. And based on the decision of the French Higher Administrative Court that is made in 2020, it is stated that biometric data is for public service. Besides, AliCAIM users freely giving a consent, minimum reliability and accuracy of the algorithm of AliCAIM IPP used. Besides, it's required equipment by leading technology that drive integrated programmatic advertising platform. Moreover, it is an offer for French nationals to identify themselves electronically. And below the slide, you can find the European case law identifier, national case number, in order to personally to discover this problem that I would recommend to do. Okay. Practical aspects we already have found. And in order to summarize the formula proposed, the legal formula has the ground for the specific law. In order to provide the technical and organizational measures that technology need to satisfy, this is based on the GDPR Article 25, that is call for the data protection by design and by default. Besides of the GDPR in 2018, European Union introduced the Cybersecurity Act, and this Cybersecurity Act is realized through the framework of European Union Agency for Cybersecurity, or is also called ENISA. I would also recommend to read more about this institution. Talking about B, the network interaction is possible through the safeguards that propose privacy-enhanced technology. This technology is operate also based on the regulation privacy and electronic communications that is in 2018 was found as a way to provide a single digital gateway for European citizens in order to have personal management of the information provided. So a single digital gateway proposed through the network connection provide access to information, to procedure, to assistance, and possible problem-solving services. Talking about C, I think that ethical perspective is the one of the crucial for all of us, for our human beings. So besides of the legal framework that I have introduced, and with respect to hierarchical mechanism of European law, we also have to involve the soft law. And this is the soft law as example, as a statement or artificial intelligence, robotics, and autonomous system of 2018, proposed by European Group on Ethics in Science and New Technologies. So, see, our output of our identity, digital identity, how to be found through the next statements. The first one is respect the human dignity. Second one, autonomy, responsibility, justice, equity, solidarity, democracy, rule of law and accountability, security, safety, bodily and mental integrity, data protection and privacy, and the last one is the sustainability, that now is also the provide digital ecosystem for European Union citizens in order to unify it and fix this digitalization in order to, make possible to organize states, community for the digital identity technology outcome. Talking practically, A, B, C, and RC have to be seen from the mechanism that I also compare to the traffic light mechanism. So in order to, make possible to move our ABC in the triangle that was represented in the beginning, there have to be some rules. And basically, the rules are very simple. These rules of data processing for our identity in the cyberspace can be seen from the rule what is prohibited, so it's not compliant, to what we have to pay attention, so it's risky, and if it's compliant, then it is allowed. So the studies have found the next outcome. No biometric data processing without knowledge of the data subject. Use for incompatible purposes and reuse of biometric data has to be forbidden. Biometric applications shall not be based solely on automated decisions. No combination with additional personal data if possible. An explicit prohibition to process biometric in central databases. Limited exceptions are determined by law only. Prohibition to use biometric system for identification without explicit law. Consent and choice of the data subject. Transparency for the data subject and the role of certification. Deletion of biometric template has to be granted by law. The protection of biometric data processing in pseudonymization way. Biometric data processing for business requests requires additional legal basis. The process of biometric for the strict public necessity based on the law of particular country. The distinctions of process and finalities need to be legally established. In the view of the study, the law have to apply it from the 3 steps before in the process and after processing. Use of verification by business is appropriate. A revocability measure could protect against identity theft and misuse. An alternative identification shall be granted by law. The trust is not in all cases reliable ground. And the distinction between characteristics that leave traces and do not is unfortunately outdated in European Union law. Okay, having these mechanisms to conduct for a human besides of the traffic light, we also relevantly ask us what is wrong and what is not wrong, and what is good and what is not good from the ethical point of view. From the ethical point of view, this is a question for all of us, for our identity as well too in the cyberspace presence. This perspective can be solved through the policy for digital identity technology. The policy proposed to combine the next statements. The first of all, policy include the information about the technology company that involved for digital identity, and that is the status quo. Demander, that is international company, ensure the digital identity. Besides, is authorized to provide the protection for process and process data. The demander relies on the PAT together with data protection officer that can make a vote over personal data of a person involved through the independent evaluation of PAT system. Besides, the technology companies work with the personal data strictly in accordance with the notification and authorization scope of each of individual. Here we also need to be to identify the age of our humans. So the humans can be seen from the perspective of adults and also childs. And in this side, the guardian is necessary to realize identity if the human is under 14 years old. Besides, once an individual, children and guardian read inside the rules followed from the policy of the technology company, it is mean that demander in the scope is valid and legitimate to conduct the digital identity. If for relevant data, technology need exceed the scope, privacy enhanced technology designed to notify through automatic set to get the permission to obtain the decision for outcome process from the user. The system conducted in the technology is responsible for the rules presented in the policy that is coming from the business companies. Next, data application statement can be seen from the perspective how we apply our digital identity. And this can include the next information: personal identifiers of the person, tokens that arise by automatic means and that relate to a particular person, audio, video, image, digital footprint, internal and external information that relate to a particular person. Besides, we have to be clear that the processing of data is not about to gather the information about life of digital presence of particular individuals that some scholars might be also think that is, risky. So the status quo for digital identity technology is about to conduct a model of legal capacity of personhood, about the income and outcome proceedings of data that relate to the particular person that is a source of this digital identity. Storage. This is also a crucial domain that have to be fixed in the policies. All appropriate measures within legal bounds to prevent obtaining data or its use by third parties not authorized by demander are on the responsibility of demander. So basically the companies have to ensure who have access to the storage with this data. And the storage of data, while the demanders have responsibility, is built on the server of demander. Besides, the personal data is became a part of digital identity technology model, and this data is permanent value for the pet. With respect to the technological progress, companies need to learn this data. This why is seen as a value. If some functionality is required to collect biometric data, the digital identity technology in principle save it separately with stronger core of protection developed for biometric specific. And the last statement, security events. The first one, it can be precision procedure. And in order to, to understand back how the status quo can be seen, if there is a risk, so the prevention can be done from the rescission procedure that is unbinding for transactions and from the process mechanism. So data have to be back to the former scope of its use. And this is called the status quo ante. This mechanism is also coming from the contract law, when parties, in case of the risk, need to be back to the former status that they had before as the contract took place. B, business expansion. While the technology companies are growing up, the business have to make a balance with respect to the principle of proportionality that is often used in European law to find out a balance of increase of production with efficient production processing. And the last one, dedicated server. The machine allocates all of its data proceedings that usually conducted from the hardware resources. So these hardware resources, RAM, storage, power, have to be, with respect to the human-centric approach of European Union, under control of the user. Ownership. This statement is not fixed yet in European Union law, but it's a statement that is often used by companies in their policy. The ownership understanding to conduct our identity represent the next three status quo. And that is basically the application for the format new information after as characteristics have been provided by a user. So the format new information by the process through the initial data is belong to the demander. The policy of the technology companies make clear about ownership status, but it's relevant to talk about the format new information because them functionalities make possible to convert this data. So that's why they see the rise to have some ownership for the outcome that they received. An individual is not claimed for this format new information respectively, and compensation for the individual is not appropriate. That is the basic statement that is understood from the perspective of the technology companies. The next one, demander has all property rights applicable to the format new information. In case of infringement, demander for judicial remedies can claim about this, and the compensation is addressed on the name of demander. And the last one, demander has intellectual capacity and patented rights to all results, including but not limited for facility, utility, services, and or products output that built by demander by applying data provided by data source. This is a status quo for policy that's proposed by the study. And talking about the recommended possible technical measures that are now fixed in the GDPR to have some legal ground, I propose to find out the mechanism of protection through the pseudonymization, anonymization, and encryption tools. They are different. The pseudonymization is a process when personal data can no longer be attributed to the specific data subject without the use of additional information, and such additional information is kept separately. The pseudonymization, that is a subject of technical and organizational measures, works to ensure that personal data is not attributed to an identified or identifiable natural person. Besides, the purpose of additional information is used for the identification of the person. Encryption. The encryption technique is the process that uses secret keys to transform data in order to reduce the risk of misuse and keep confidentiality for a given time. Due to the needs when the original data has to be accessible, the transformation applied by encryption algorithms to make data reversible, that is called decryption. Decryption provokes the personal data to be readable, and consequently the identification of the person is possible. The anonymization technique is different because it's a process when data cannot be associated to a specific individual. Besides, an individual cannot be identified or identifiable. An important notice to warn all of us that this data is not considered as a personal, and that is not fall within the scope of the GDPR. But the anonymization technique need to be applied in order to achieve irreversible de-identification. These safeguards can sound great, but applying the Titanic phenomenon that has happened in the past, I would say that the builders of the Titanic were so confident of its stability that they did not have enough lifeboats when the ship sank. The same true, in the opinion of my study, can happen with the digital identity technology, because this technology, this status quo is viewed as infallible. This risk to fail as failed Titanic. And when its breach happened, no law nor technical experts will not be able to provide adequate safeguards. In the opinion of the study, the ethics would solve the problem. And this is the next box about ethics that I prefer to give to solve for my colleague Gatis. Thank you.
Hello.
Mhm.
I will share the screen. Now everyone sees the screen?
Yes.
Yes.
Yes, okay. Thank you. My name is Polis. I'm a qualified lawyer, a security professional, member of Security Professional Association, also a schooler at VA School Business and Finance. So, Daria talked about a lot of digital identity, and now I'll talk a little bit of ethics, giving just food for thought. What is ethics? What is ethics in cybersecurity? Webster College Dictionary defines ethics as a discipline dealing with good, bad, with moral duty and obligation. In more simple words, it's the study what is right to do in a given situation and what we ought to do. Ethics, as we know, is a complex term. In many cases, we refer to it as a soft law, as a kind of the soft law of the soft nation, but it's a complex term with many consequences and meanings. Paul and Elder in 2006 describe ethics as a set of concepts and principles that guide us in determining what behavior helps or harms sentient creatures. Socrates once said, the most important thing in life is not life, but a good life. Cybersecurity is a form of risk management, and because of those risks substantially affect other parties, there is a default ethical duty to disclose those risks when identified. Therefore, affected parties can make informed decisions. In in computer security, cyber ethics is what separates security professional from the hackers. Simply put, actions that are technically compliant may not be in the best interests of the customer or business or company or people, and security professionals need to be able to judge these matters accordingly. Some basic ethical issues on the use of IT in a global network consists of personal privacy, data access rights, harmful actions on internet, These basic issues have been solved partially using technological approaches such as encryption techniques, SSL, digital IDs, computer firewalls, etc. Main thing for cybersecurity ethics is that the trust is being a central theme in the ethics of cybersecurity. There are a lot of different approaches to ethics of cybersecurity. In this slide, I'm showing you that there are some worldwide known certification organizations which provide industry-approved certificates regarding to information security. Also, some tries to give some ethical guidelines, but Computer Ethics Institute, 10 Commandments of Computer Ethics, it's old and it's not valued by today's standards. Society parts such as doctors, police officers, lawyers, etc., also cybersecurity professionals are epistemic society, but unlike these societies mentioned before, cybersecurity professionals has no unified ethical code, which pose risks to integrity, availability, and confidentiality. If we don't meet triad, there's no need for there's a lack of knowledge, lack of everything in information security. Certification organizations and training institutions, as shown in this slide, have slightly different approaches to ethics standards and quality, as well different national understandings and legislation. Vivid example of certification is a certified ethical hacker. Certified ethical hacker certification companies at the EC Council announces that certifications providers will teach information security professionals how to lawfully hack an organization. But according to the law in Latvia, it's assumed a criminal activity and punished by criminal law. Also, as I mentioned it before, some guidelines have been advised for the years, but it was written decades ago and is not valid today. A code of ethics is important because it helps employees or organizations, organization members, businesses make decisions that are in line with the company values in absence of a clear rule, direct supervision. A code of ethics can improve decision making at a business and make it easier to employees to be autonomous. Because my thought is that ethics is capable to safeguard, to get better save the people to the future, not like a robust law. For example, for these certifications, I will deliver that example of driving license. We all have the driving license. I also have. With one license, at least in Europe, I can drive in Latvia, Germany, Spain, Sweden, etc., etc., etc. Why? Because there is basic rules, basic guidelines that is known to all, and breaking them makes consequences. Even you can lose your driving license. What is the main problem about this certification and certification organizations? That if maybe I have ISACA certification that is known in Europe and the USA, if I behave dishonest, unethical, and lose these certifications, I can easily go to other certification organization and get certificate. So, why ethics matters? Ethics, moral principles that governs a person's behavior, is a critical part of any sound cybersecurity defense strategy. Without clear ethical standards and rules, cybersecurity professionals are almost indistinguishable from the black hat criminals, hackers, against whom we seek to protect system and data. Cybersecurity professionals are like a technological gatekeepers, like goalkeepers, in respective organizations entrusted with general responsibility and a high level of access needs to carry out their roles effectively. With legal, medical, accounting, and other established professions have legally binding codes of conduct overseen by long-sailing regulatory bodies. IT security professionals have yet not established formal guidance or universal checks and balances. The industry lacks an independent register to determine who can participate in ethical hacking or security searcher or in security providing or how to secure information. So cybersecurity leaders right now must rely on reputation and background checks alone to determine trustworthiness and potential hires. If IT professional betray this trust by behaving unethically, there's no third-party committee or board to evaluate the consequences of these actions. And the rule, in the context of professions as well, rogue security professionals can't be struck off the registers or removed from a database because such a database doesn't really exist. As I mentioned before, the trust is a being central theme in ethics of cybersecurity. We need to answer some questions. So, what information about individuals can be revealed for others? What information about individuals should be kept in the database, and how secure is information in the computer systems? Who should handle data privacy on the computer networks? What's allowed to access the data information? How can safeguards be introduced to ensure that the information can be accessed? And etc., and many more questions. The effects of neglecting cybersecurity ethics is that in our cyberspace environment, increasing number of cyber attacks targeting enterprises, but with lack of information about characteristics of the attacks and their possible impacts. Therefore, it's important to analyze existing cybersecurity studies and come up with a comprehensive view that security in an ethical context to gain complete pictures that threatens facing small, medium businesses or big corporations. Due to the lack of ethical behavior, small, medium business enterprises can face a number of vulnerabilities. For instance, lack of competence can make any organization vulnerable to social engineering attacks, like phishing, like whaling, like every stuff I can do on the email, like calling and pretending as I'm from the bank and asking you for your credentials. If an employee is not competent enough to differentiate a legitimate business email from phishing email, it puts all organizations at risk. It's just little things. I'm not talking about the network segmentation or the stuff that is needed to take safeguards. That the easiest one and then most frequent one. What's needed to move. Furthermore, the lack of concern of professional development and to update one's knowledge can lead to lack of awareness of current cyber threats, such right now is happening a lot of DDoS attacks. Disturbed denial of service, social engineering attacks, hacktivism, credential harvesting malwares, asking to people give money to encrypt the information. Due to the various reasons, including the fear of being sacked, employees might choose not to report cyber incident, especially if it's caused by their negligent behavior. Not reporting an incident can be considered dishonest. For example, not informing about the incident would make it difficult to contain and lead to spread of malware through the networks. As a result of unethical behaviors, we can face a number of risks such as loss of reputations, profits, money, employees, property. Why at the first slide I mentioned the triad, because it's essential to protect information stored within organization computer systems. In addition, security professionals use triad to understand and assess organization risks breaking down all the potential threats, vulnerabilities, attacks with each section. If you neglect consequences, if you neglect this triad, I can assure you that for business it's lethal. As specified by Australian Computer Society Ethical Code of Conduct, honesty is an important aspect of ethical behavior. Also, the trust, honesty and trust. We need also understand. I will regain the information that of recent. It was in 2017. It was Equifax case. That's a reminder how unethical actions caused the millions of dollar losses. That is what you get when you are neglecting security. So, thank you all. These are some list of information you could read to understand ethics more broader, because unethical actions can bring down the businesses, the countries, the people lives. Thank you a lot.
Thank you so much, Daria and Gaddis. Because of time, maybe a question or two. What do you think?
I'm ready for questions.
Okay. Does anybody have any questions? I have a question, maybe to get started. On the 3Q slide, the awareness part. Does awareness mean some sort of understanding as well? Is there a level of awareness? Daria, what's awareness kind of mean in that sense?
Yeah, sorry, I was muted. Yes, there are three elements, the three core that I have found, they're equal to the sense of the justice that I was mentioned in the previous slide. And you're right really to say that the sense of the justice is the possibility of the human being or evaluate what's going on. And this capacity is seen from the perspective of the sense of justice, the capacity to understand, to act, and to apply. So awareness from the legal point of view as a value that granted by European Union is seen from the perspective to understand, that is safeguarded by the sense of the justice.
Okay, right.
Thank you so much for this question. I would really recommend, also refer to the methodology besides of the legal doctrines, legal framework, art sciences and math sciences that I used. Also the philosophical aspect is the most powerful to assess the sense of the justice. So I would also recommend to find out the further philosophical studies in order to understand what the awareness, that is the possibility to understand, means from the self-evaluation to justify. And this is how justified our digital identity. Yeah, thank you so much for the time given. And if there's no other questions, I would say thank you for my colleague Gatis to resolve the box of ethical problems And I also want to say thank you, Mark, to be a moderator of our workshop as well. Thank you one more time for the National University of Yanmin Town University, and specifically for the Faculty of Law, Dean, Professor Thomas Chen, to make possible this workshop. Thank you so much. If there's no questions, I would propose to have a stop, and we are looking forward to have another possibilities to perform our next studies about the status quo of digital identity technology that can be found deeply later. I'm looking forward to analyze this problem even more, and hopefully in the future I would propose these studies to the Faculty of Law again, but from the modern, new perspective. Thank you so much one more time. Yeah.
And thank you again. And we look forward to future collaboration, and maybe we can make this a regular workshop. I hope we can make it regular. But thanks again to our presenters, and everybody give a nice virtual applause. Thanks.
Yeah, if there will be questions, I see that in chat there are some questions. So I would just write in the chat my email. And if you guys have questions, please write me, and I will back to you by email conversation, and maybe we can also discuss about possible problems through the online meetings. I'm looking forward for this. And I also would suggest for my colleague Gatis, also please specify your email in the chat, so our audience can be interacted with us. Yeah, I just sent my email. Due to the limitation of time, please let's be in touch. I'm looking forward to know you and your studies too. Thank you.
Thanks, everybody. Take care.
Okay,
Thank you.
bye-bye.
Thank
Have
you.
a nice
Have
day.
a good day.
Bye-bye. Have a good day.